And now we'll proceed. When now you are a registered, trade union as such, under what circumstances the registrar can withdraw, revoke or cancel the certificate of registration? Under what circumstances the registrar can withdraw or revoke the certificate of registration? Namely, one, when the certificate is obtained by fraud. In the previous question paper, the question has come, pertaining to previous question paper or 2011 question paper. Some question, a problem has come. What is the problem? A trade union has obtained the certificate of registration by mistake or fraud, and registrar wants to, registrar issues a notice to withdraw the certificate of registration, but the trade union challenges it. Trade union refuses the same and challenges the same. Whether trade union will succeed? No, trade union will not succeed, because under section 10 of the Trade Union Act there are certain grounds wherein the registrar of the trade union can justify by issuing the 2 months notice in writing indicating the reasons thereof as to what all the grounds, as to what particular reason he is now proposing to withdraw the certificate of registration. Such may be when the trade union obtains a registration by fraud or mistake. 2, when the trade union allows the rules of the trade union, when the trade union allows its rules to contravene the provisions of the Trade Union Act, when the trade union ceases to exist, when the trade union fails to commence or carry on its activities and it is like a dormant when it ceases to exist, when the trade union contravenes the provisions of when the trade union while carrying on its activities contravenes or violates the rules rules that have been registered as such, and when the trade union allows any rule in force inconsistent with the provision of this act, and in such cases, in any of these cases when it exists, the registrar of the trade union can issue a notice, 60 days of notice, in other words, a 2 months notice in writing indicating any of the reasons, whichever is present, whether it is obtained by fraud or mistake, whether the trade union has ceased to exist, whether it is willfully willfully and after notice from the registrar contravened any provision of the act, whether it has rescinded any rules. At the time of registration, set of rules you have submitted, and on that faith that you will comply with those set of rules and all that he has registered. But thereafterwards, after registration, it is found that the registered trade union is altering or rescinding any of the rules, even without informing the registrar, then carrying on trade union activities, it is violative. In such cases, the registrar can issue a 2 months notice indicating any of these reasons thereof, whatever existing, and he can proceed for withdrawal or cancel or revocation of the certificate of registration. Okay, that's one. Then you have got second one, appeal. When the registrar cancels the certificate of registration, can it be appealed against? Yes, you can appeal. Suppose if it is a other Mofussil towns and all, you can go to the district judge on appeal, or if it is a presidency town or state headquarters, like, you can go to the High Court, make an appeal within 1 month from the date on which a registrar has passed an order for the withdrawal or revocation of certificate of registration. This is what pertaining to your registration as such. Therefore, under section 11, under section 10 of the registration, under section 10 of the Trade Union Act, a registrar is empowered to cancel or withdraw or revoke certificate of registration under these circumstances, provided he complies with the procedure. 2 months notice in writing indicating the reasons thereof, and it is like a show cause notice why your registration certificate cannot be cancelled, and if appropriate and convincing reply is not given, registrar will proceed. Of course, you can appeal against the order of the registrar, that also. Then we will proceed now. Now you are a registered entity. Section 12 says that upon registration, section 11 says appeal to the High Court, wherein we are in a state headquarter or presidency area, or to district court as such, district judge court in any other, in any other provinces. Section 12, you become a distinct legal entity, you can own the property, etc. Section 13, certain of the enactments do not apply, like Cooperative Societies Act. Then you will see certain of the enactment that is not applicable to trade union, namely Society Registration Act, Cooperative Societies Act and Companies Act, they are not applicable. So therefore the following act shall not apply to any registered trade union, and the registration of any such trade union under any such act shall be void. Namely, these enactments are not applicable. Therefore, under that, if at all any registration of the trade union is done, it is void. What are those enactments do not applicable to trade union? They are Cooperative Societies Act, Registration Act, Society Registration Act and Companies Act 1956. Then 14 says bundle of rights. Trade union upon registration becomes a distinct legal person. Understand? Therefore, no trade union can exist and carry on its activity without registration. Registration is mandatory. What are the rights of the registered trade union? As I said, upon registration, you will acquire these many rights. Namely, one, your rights are, one by one, I will list them. One, a trade union is entitled to have name, right to name, right to change the name, those many things. Right to acquire, hold, dispose. Right to acquire, hold and dispose of movable and immovable property in its own name. 2. Right to sue and sued in its own name. Trade union has got this right again. Right to sue and could be sued in its own name. Then fourth one, right to have common seal. Fourth one is right to have common seal. Fifth one, right to constitute general fund. Sixth one, right to constitute a political fund. Seventh one, right to amalgamation. Eighth one, right to what is that called? Right to dissolution. Whatever I said, they are not intended to be exhaustive, but you will get these many rights once you are incorporated. You are a registered trade union. You can have your name. You can change the name, but subject to restrictions, no doubt. You can acquire, hold, dispose. You can enter into contract. That is also should be the part. 9. Trade union can enter into contract in its own name. Then you can sue or could be sued in its own name. Then you have got the right to constitute general fund, right to constitute political fund. Then you have got right to amalgamation. You have got right of dissolution. Whatever stated, they are not intended to be exhaustive as such. But these are the rights. Let us now focus on some of the rights. That is extremely important. That means what all the purposes for which general fund of the trade union could be. Anyhow, it is a right of yours. Under section 15 of a trade union act, you have got general fund. Trade union, it is one of the rights of the registered trade union to constitute general fund. There will be questions like explain the rights of registered trade union to constitute, explain the rights of registered trade union with more emphasis on general fund and political fund of the trade union. Now again, another question can be there. Explain the purposes for which general fund of the trade union could be spent. What are all the various purposes for which general fund of the trade union could be spent? Whether from the general fund you can you can grant money for conducting or rather to meet election expenditures of your member who is contesting any election, like whether it is at the taluk level, at the district level, at the village level, at the state level, or at the parliamentary level. If at all you have promoted the candidature of your member to contest in any of these elections, whether for that electioneering, whether that to pay the nomination fee and all, whether money can be spent from the general fund, because that's a question. It is not possible. General fund is applicable for some of the following the purposes, objects on which general fund of the trade union could be spent. What are those objects? Object number 1. Right to general fund could be spent for the following purposes. 1. It could be spent for the payment of the salaries and allowances and any other expenses relating to the office bearers of the trade union. It could be spent for payment of salaries. Okay. In other words, I will tell you that the payment of salary and all, A trade union need office, and you need to have office staff. They are not employees of any trade union, and whatever. When you establish your registered office, and in that office you have appointed the staff and all to carry out your the administration of trade union, that office staff will have to be paid salary and allowances, and even the allowance is applicable to the office bearers of the trade union. Office bearers of the trade union, for example, they may have to move around for the purpose of promoting the objective of the trade union. They may have to be moving around, and this is in furtherance of the objective of the trade union. Those expenses may be borne from the general fund. Okay, I will tell you from where this general fund constituted. While discussing about section 6, I have told you that the registered trade union have got the right to constitute the general fund, and to the general fund contribution is compulsory. Every member of the registered trade union shall contribute to the general fund. In case if any of the member fails or refuses to contribute to general fund, then he will not be administered with the benefits of the general fund. One, he may be denied of the membership to the trade union. Two, if you don't contribute, then your employment will not be lost. You will continue to be an employee, but your membership to the trade union may be rejected, or they may retain you in the membership without any benefits. That can be the only possibility. But under no circumstances the money could be spent from the general fund for political reasons. For that, under section 16, there is a separate, that's the right of the trade union, there is a separate fund called political fund as such. Now, let me tell you that these are the purposes for which, when you know that, the monthly subscription should not be unreasonable, it should be very nominal as such, and it can be changed from time to time depending upon the need. Anyhow, it should not be misappropriated or misused. Which one? General fund. General fund for what purposes? For which? General fund, because you are constituting the general fund by subscription from the members, and those members who are contributing to this general fund as a compulsion from out of their wages. Wage itself is minimal, and you are contributing to the general fund, and the general fund, if it is misused, then it will be very painful. That cannot be bearable as such. Therefore, the general fund, the money from the general fund could be spent for the payment of salaries, for the payment of allowances, for the allowances to be incurred for the expenses to be incurred to the office bearers for the purpose of promoting the objective of the trade union. 1, 2. It could also be spent on legal proceedings, for prosecution or defense of any proceedings, if it is needed. If a trade union wants to, say for example, a case has been filed against a member of the trade union, or a member of the trade union will want to file a case against the case against the other party, either for prosecution or for defense of any particular case. If that is essential for the trade union on behalf of the members to protect or prosecute, then such can be either contested or prosecuted, or could be defended. You don't know whether you need to file a case on behalf of the members, or whether you need to defend a case that has been filed against either the trade union or any members. If such contesting or defending is needed for the furthering of the object of the trade union, then amount could be spent from the trade union, and then fund may be spent for the purposes security of a trade union or any of the members. What is that security? The third one, as I said, for safety, security of the trade union or any of the members. What is that? Oh, you may undertake insurance. Hardly a premium to be payable. If you take insurance on behalf of all, not that employment insurance will be there, either ESI or under the Employee Compensation Act, whatever, it will be there. But to carry out, to undertake an insurance in the name of the members of the trade union, you may also undertake that. You may also procure that. Thereby, you can ensure the security of the employee. Security of your members who are no doubt employees. Fourth one, you can have some from the general fund. Therefore, in the beginning itself, I told, don't misappropriate the general fund, as it is meant for some noble causes like old age, sickness, widow, pension. Old age pension also possible. Old age pension, widow pension, sickness benefit, then educational benefit. Okay. Then in case funeral benefit. Okay, all these you can undertake from this general fund as such. These are all different purposes. I have stated in the fourth does not mean that it is fourth. They are different. See, fourth, fifth, sixth, seventh, eighth, like that. And then you proceed to 9. You will find one more. That is, general fund could also be spent for conducting any research or to carry out any literature work. It is possible. And say for example, when the festival is approaching, you want to conduct some of the competitions for the children of or for the employees, you may do so. And the prize winners will be felicitated. They will be given with the awards. And the general fund could be, even for meeting, get together, funds could be utilized. But don't do only for these purposes. There are many other purposes as such. What is that? Promote the employment. You need to promote the employment also. How to promote the employment? Conduct research activity, conduct literature. You invite such articles from the members and you can publish. When the employer feels that it should be my botheration and trade union is bothering about how to, trade union is bothering about the current trends of the employment and how to upgrade them, how to advance them. They are conducting research. They are writing articles and all. Oh, they are contributing. I'll tell you, if you do that, then employer may also contribute to the general fund. Normally, general fund is the corpus of your subscriptions. But one day you will find, if at all you are working for this noble causes, one day you will find the employer will also be contributing to the the general fund as such. So corpus or money made available in the general fund could only be inflated. That is the one explanation. Explain the purposes for which general fund of the trade union could be spent. These are the purposes for which, therefore, from general fund, no money can be spent towards political or election purposes. For example, any of the member or office bearer of the trade union may be willing to contest election, but fund cannot be utilized for the purpose of fund. No amount can be utilized for the purpose of election. For that, there is a separate. We will proceed to that next. That is called PF. Okay, what is a PF? PF is called political fund. Under section 16, it is not section 15. Under section 16, it is the right of the trade union to constitute a separate fund called political fund. And to the political fund, as I said, the contribution to general fund is compulsory, but whereas contribution to political fund is optional. What is it optional? No member of the registered trade union can be compelled to contribute to the political fund. No action can be taken against any member of the trade union. It will never disqualify. You cannot be disqualifying the members of the trade union from the membership of the trade union simply because they have refused to contribute to the political fund. Because it is a rule. Under section 16, contribution to political fund is only optional. Those members who are willing to contribute, they can contribute. Otherwise, there is no compulsion. You cannot compel or mandate the members of the trade union to contribute to the political fund as such. And if at all, if any member of the trade union is compelled to contribute, then it is wrong on the part of it is it is not acceptable. That's what I said. If at all any member of the trade union compelled by the trade union to contribute to the political fund, then under section 10, registrar can issue notice for withdrawal. That action can be initiated by the registrar. Therefore, the political fund contribution is optional. Okay, and this is from the political fund. Whoever willing to contribute, they may contribute. And when a political fund is constituted, money from this can be spent, necessary expenditure that may be incurred to promote civil and political interest of any member of the trade union. For example, any member of the trade union wants to contest any election. Okay, whether it is a state assembly election or parliamentary election or Jilla Panchayat election or whatever form. In case if any member wants to contest and if the trade union feels that such an election, we should promote the civil or political interest of the member of the trade union or office bearer of the trade union, we need to support that candidature, because if he becomes a candidate, then that will be beneficial to the trade union as such. If the trade union finds that political or civil interest need to be promoted, then it can promote. Money is needed. What for? To file nomination fee. Then before, during and after election, meetings may have to be held. Before, during and after election, meetings may have to be held. For holding this meeting, for to distribute the pamphlets, literature, pamphlets, etc., money could be spent from the political fund as such. Okay. And I said that under no circumstances for these political reasons, for election reasons, money from section 15 general fund can never ever be spent. And if at all, then it is violation as such. But from political fund, if at all surplus money is there, you can give away to general fund, no problem. Okay. Under section 17, 18, 19, where we will discuss. So far we have discussed the rights of trade union. We are discussing that also. Right to have privileges and immunities, which are not listed, It goes to 10th. There are rights. A registered trade union is entitled to have rights in respect of their privileges and immunities. Normally, when you have formed a trade union, invariably a trade union may have to, call all the members, and they may have to enter into some sort of agreement. Let us not, do our work tomorrow. Let us boycott the work. Let us strike, something like that. Whether employer can treat this, trade union, you are all entering into, you are giving the call to all members, thereby entering into an agreement to commit a crime. Sorry, you cannot say. Mr. Employer, you cannot count or consider like they are entering into an agreement to commit a crime. They are entering into an agreement so as to, call off the employees from the work, call out the members of the trade union from the work. They are all agreeing to resort to strike and all. It does not mean that they are entering into an agreement to commit a conspiracy. It is not possible. You cannot count that it is under section 120A and under section 120B. It is not at all a conspiracy, criminal conspiracy. They cannot be prosecuted under IPC for having committed, they cannot be prosecuted under section 120A and 120B of IPC on the ground that they are conspiring to commit an offence against the employer or employer, nothing like that. See, if a trade union cannot enter into an agreement with all the members of the trade union, why trade union is formed? And in the beginning itself we have discussed, trade union is formed for the purpose of promoting some of the objectives, and safety, security, employment, enable workers' participation in the managerial decisions, to educate the workers about the need to have discipline, etc., etc. We have discussed sufficiently. Therefore, we may have to, as a trade union, we may have to group together, and we are entering into an agreement. Of course, when we place forth the reasonable demands, if the employer does not comply with, then we may have to give a call by inviting all of them and entering into an agreement. Hey, employer, you cannot consider this kind of approach, this kind of exercise by the trade union as a conspiracy, and it is wrong on the part of. But in the exercise of the same powers, if the trade union, in the exercise of same powers, if the trade union enters into an agreement to commit a crime, see, when you have entered into an agreement, requesting all the members to call off from the work, we will stage dharana and all. See, this is to further the objective of the trade union. That is to secure the better conditions of employment, better terms of employment, etc. That can be there. But in the alternative, if you say, instead of this, if you say that, hey, we will, if employer, see, we will make a demand, and we have made it, but employer is not conforming, employer is not meeting affirmatively to those demands. Therefore, we will stage dharana. This is what you are entitled. And if the employer initiate any criminal proceedings, you cannot be arrested, and you are entitled to be immune of those criminal proceedings, unless whatever alleged upon you is that you have entered into an agreement to commit a crime. Then in which case no immunity, no privilege is allowed. You will be prosecuted. Suppose if you enter into an agreement and called off the strike and asking the all members, let us not allow the peaceful environment, and let us cause damage to the employer, person or property of the establishment. If at all such an agreement is entered into between employer and employee, if at all such an agreement is entered into between trade union and its members, then such an agreement is termed to be void. And the parties who are, the trade union will not be allowed to enjoy the privilege or immunity. Then the employer can prosecute, because you have entered into an agreement with that idea. If the employer does not comply with our demands, then we will go on strike and cause damage to the property or person of the employer as such. You cannot do it, and in case if you have determined to commit this kind of violence, then it is an agreement to commit a crime. For in respect of that, you are not entitled to any immunity as such. But otherwise, you are entitled to immunity for any such. Say, for example, break away from the contract of employment. Employer might initiate action against the office bearers. Why you are meddling? You know that, first of all, in almost all the trade unions that we find in India, the office bearers of each trade union, they are not attached to the establishment. Even outsiders will be there. Maybe 50 to 60% of the office bearers belonging to your establishment. Other 40% of that trade union belongs to outsiders. They are outsiders. So as such, outsiders, this outsiders influence, outsiders interference may be affecting the establishment. But if you are carrying on your activity according to the objective, according to the purpose of the trade union, then as long as you are carrying on your activity to attain those, to promote those objectives, you are protected. But when once it is found that you have entered into an agreement to commit a crime, then you will not be protected, you will not be entitled to. In which case, of course, criminal prosecution will happen if you have purposely called off, purposely requested all members to cause damage to the personal property of the employer. Two, you are also entitled to privilege and immunity in the case of civil proceedings. Obviously, employer will say that, hey, trade union, why you are interfering with my business by asking the employees to keep away from work and all. They are breaking their respective contract of employment which they have entered into with me. No, they are the members of our trade union. When they being the members of the trade union, we are entitled to, they sought our help, we have placed the demands before you, but you did not comply with that. Obviously, we will give a call to break away from the contract of employment. I know that has caused some damage or loss to you, but comply with our demands. In reciprocity, we will get back to our work. But we should continue to work till you will comply with our demands at your own free time. That is not possible. Okay. So, in which case we will give them a notice that by calling all of them and requesting them to break away from the contract of employment, to report to the employment, but don't do any work. You may consider, Mr. Employer, that it is one way or the other interference. It is not so. Those are absolutely needed for the purpose of the trade union's objective is also that also, among other objectives. It is one of the objectives to secure the better service conditions, safety of employment, etc., etc. In that regard, we can, and definitely whatever the trade union have given a call to break away from the contract of employment, to report and not do any work, etc., etc., then in which case you are entitled to the immunity. In case if a civil proceeding has been filed against you, the trade union, by the employer, you are entitled to the immunities under section 18 and 19. So section 17 dealing with the immunity from criminal proceedings, 18, 19 from the civil proceedings. When you will be entitled to immunity from civil suits, no suit or order or legal proceeding shall be maintainable in any civil court against any registered trade union or office bearer or member of the registered trade union in respect of any act done by them in furtherance or in contemplation of the trade disputes. Okay, and those conduct on the part of the trade union is extremely essential to further the objective of their trade union, though it may be interfering with the trade or business or employment of the employer, though it may have the effect of breaking away the contract of employment with each member has entered into with the employer, but that is very, very essential. It may be interfering with the employer's right. Okay, it may be interfering with the employer's right, but it is equally important for the member of the trade union. I mean, office bearers of the trade union or the entire trade union is equally important to further their interest, to promote their interest, to safeguard their interest. They have no other go but to but to keep away from working, break the contract of employment, or interfere with the trade, business, or employment right of the employer, etc. Okay, it is not that possible. If you have the right to investigate, I mean, it is the concern of, it is a field of yours to invest capital and carry on the employment. It's a field of ours to give our labor for the carrying of that employment. But that can go hand in hand when the relationship is harmonious. But if the employer is not at all conforming to the demands, reasonable, appropriate demands of the employees, then employees are entitled to go on, exercising any of these rights and they will be helped by their union, of course. And the civil proceedings, that is a breach of contract, something like that, or a proceedings may be initiated in a civil court, or even against the trade union or any member, suit may be initiated for, they have committed a tort and all, something like that. No, they are entitled to immunity, provided all of this you do for furthering or promoting the objective of the trade union as such. Okay, right. Then the other things that we need to refer, section 21. What is the section 21 provides for? Section 21 provides for whether minor can be a member of the trade union. Minor can be a member of the trade union, provided minor can be a member of the trade union. So when provided he should have completed, that a minor cannot be an employee unless he has completed the age of 15, unless he has completed the age of 14. That means he is in the first moment of 15, but subject to various qualifications. What are those qualifications? Subject to various qualifications. What are those qualifications? Qualification is that he should obtain the fitness certificate. He should be, suppose if a person of 14 completed, he is in the first moment. If the employer wants to employ, then such employment may be subject to various restrictions, like when the employer considering that child worker completing the age of 14, he can be employed subject to several qualifications, like one, he should have completed 14 and he is in the first moment of 15, therefore. Second one, to which job you are going to induct him, and the third one, his mental and physical fitness need to be examined by the certifying surgeon. When the employer is sending the child worker to the certifying surgeon, one thing is guaranteed, that he has completed the age of 14, and now whether his physical fitness and mental fitness is good enough to take up this employment which the employer has suggested. Therefore, at the time when you complete the 14, you can be considered for employment, correct? And that is not good enough for you to be a member of the trade union. For a member of the trade union, not only that you are an employee, but also you should have completed the age of 15. That means you are in the first moment of 16. And when you do that, of course, you cannot be office bearer of the trade union. A minor can be a member of the trade union provided he completed the age of 15. A minor can be an employee provided he completes the age of 14. A minor can be a member of the trade union provided he completes the age of 15. A minor can, when being a minor, being a member of the trade union, he cannot be eligible for being appointed as the office bearer unless he completes the age of 18. Correct? A minor is unfit to be office bearer, disqualified to be office bearer, and other things he can execute document instruments. He can ask for accounts. So those rights he can enjoy. Right? Then whether trade union can change the name? Yes, a trade union can change the name. How? A notice regarding a notice containing the proposal for change of name shall be sent to all the members of the trade union, and you will hold the meeting. Correct? A notice in writing has been served to all the members regarding change of name, and a meeting will take place on a particular day. I don't know whether all members will come, If all members, whatever it may be, notice has been served to all members, and on the date of meeting, how many members are present in there? Out of that members are present, at least 2/3 must support for change of name. Understand? 2/3 must support. Out of the members present in the voting, at least 2/3 of the vote must be for change of name. Then that resolution must be signed by 7 members of the trade union and secretary, and then sent to the registrar. Section 23 and section 25. A trade union has got the right to change the name, provided they comply with the procedure. But whatever change in name, after holding the meeting and after getting the approval by 2/3 of majority of the members present and voting, and then it will be signed by the 7 members of the trade union and secretary, then you will send to the registrar. But registrar under section 7 may again exercise the power. Hey, you have changed the name, but the change in name is inconsistent with the names already in the register. It is resembling, it is identical, it is inconsistent. In that name we cannot proceed with the. So he may, under section 7, serve a notice. You are already a registered trade union in a name, but you wanted a change, therefore under section 3 you can change the name, under section 25 procedure is followed. But the change in name is not good, as it is in that name already trade union existing, or it is so identical or resembling, therefore inconsistent. Registrar under section 7 of the Trade Union Act can issue the notice for change of name again. Okay, you follow that procedure, but it is your right procedure also I have told. Then under section 24, you have got one more right to amalgamate. What is by two or more registered trade unions amalgamating. And what is the procedure? The right to amalgamation under section 24. Procedure is contained in section 25. What is the procedure? In both the trade unions, procedure is that in both the trade unions, let us now say the two trade unions, 2 or more I said, let us now take examples A, B, C. 3 trade unions, registered trade unions, 3 registered trade unions, namely A, B, C. They want to merge. Therefore, what is the procedure? This is the right of A, B, C for amalgamation or merger. But they have to follow the procedure prescribed under section 25. What is that procedure? Separately hold a meeting. Issue the notice to all the members, correct? So there will be 3 meetings taking place. It need not be at the same, one at the same time. 3 meetings will take place. 1 in A, 2 in B, 3 in C, trade union. What is that A trade union meeting taking place? What is that means? It is this. Resolution. The agenda of the meeting, where a notice of the meeting is issued to all members. Okay, in all the 3. See, A trade union has sent a notice to all members of A trade union that the agenda is merger with the B and C. Likewise, B will issue notice to all its members for merger with A and C. C will also notice to all members for merger to A, B, C, like that. Okay, right, done. Second one, whether all members will present out of the I don't know. That you cannot ensure. You have issued the notice to all members of each and every trade union. A will do for its members, B will do for its members, C will do. So separately meetings are taking place. And agenda is, amalgamation. Out of the members present in A, out of the members, all members have been issued notice, how many members will be there? That many members. Out of that, at least 1/2. Okay, out of that, half of the members should be favoring that amalgamation. When half of the members approves it by that majority, then amalgamation will take place. Then there may be issues like what name they will contain. Okay, similar procedure will be followed in B, similar procedure will be followed in C, and then it will be signed by 7 members and secretary. This also will be signed by 7 members secretary. This also will be signed by. Then all these copies should be served to registrar. All these resolutions of A, B, C should be dispatched to the registrar. And what name you have contained? A, B, C. You are separately A union, A registered trade union, B registered trade union, C registered trade union. But what will be you now? Now you are ABC or some other name, whatever you have proposed. Yes. A, B, C separately holding the meeting, signed, approved by one half in each of the trade union, registered trade union, and signed by each and every trade union's 7 members and secretary, and then dispatch it to the registrar. Section 25 contains a procedure for amalgamation, and that can be effective. Okay. That name also you should suggest. Then section 27, dissolution of the firm, whether dissolution of the trade union. Any the trade union, any 7 members of the trade union plus the secretary, after holding a meeting, by a majority decides resolving to dissolve the. Actually, the meeting of all members should be there, and they should be supporting by majority. And in the meeting, the agenda is regarding the dissolution or termination of trade union. If that particular proposal is accepted by a majority and signed by 7 members of the trade union and the secretary for the termination, for dissolution of trade union, from that date when you have passed the resolution for termination of trade union, within next 7 days you should serve the copy to the registrar. Okay. The day on which you have decided to dissolve and by majority and signed by 7 members and secretary, from that date within next 7 days you must send the notice to a registrar for dissolution. The copy of the resolution should be sent to the registrar. Registrar, upon seeing that procedure has been complied with for the resolution, for the dissolution, he will cancel the entry in the register as dissolved. Okay. Then there will be one issue regarding the recognition under section 28A to section 28I. It is still a provision. Because it is not yet operative. But is it mandatory? When a trade union got registered, and upon registration, whether recognizing a registered trade union, is it mandatory? Actually speaking, when the registered trade union, after its registration, willing to be recognized, then it may make an application to the employer. Under section 28A, it may make an application to the employer. If the employer also serves a copy of the registration and the objectives meant for it all, detailed you submit. When the employer fails or unreasonably, quite for inappropriate reasons, if he is not recognizing it, then you may make an application to the labor court to intervene. You are making an application to the labor court for an order to order the employer for recognizing the registered trade union. In which case, when an application is made by the trade union before the labor court, the labor court will issue a notice to the employer. You know the content of the notice. Mr. Employer, an application has been made by the trade union for registration. It seems you have not granted. Why the registration cannot be granted? You are required to show cause within such a date. The labor court will issue a notice, and employer, you are bound to comply with the order issued by the and you have to communicate in writing to the labor court regarding the reasons on what grounds you have refused the recognition. If the labor court is not satisfied with it, will order employer to recognize the same. Okay, and upon recognition, trade union is entitled to all those extra privileges, extra facilities, etc. Right? Then ultimately we need to see where there is a strength, then where there is a unity, there is strength. A trade union serves many purposes. Most utility purpose is that it is a platform, it is a forum, it is a better representative of workers or the members who are the employees, workers. It is a better representative of their interest, and through this platform, the employees or the workers can can air out their differences, can ventilate their problems through the trade union to that of the employer, so as to secure the safety of employment, better terms and conditions of wages, better conditions of employment, etc. you can ensure. Oh, when that is the case, I think if I go all alone to the employer with some demands, no guarantee that employer would respect me, employer would comply me. But when the trade union goes, employer will be extra careful, because the trade union has come not in individual capacity. Trade union office bearers have gone in their representative capacity. Obviously, in case if any request is made, in case if any demand is made, in case it may be demand maybe for promotion of employment, for better conditions of employment, better wages, better facilities, better working hours. So whatever we make a demand, that is genuine demand, reasonable demands. When we make our demands through the trade union, employer will not be inclined to reject or refuse or denial mode. He will not be in a denial mode. He will be in a compliance mode. How can I comply with the? He can't be harsh. Employer can't be harsh, because that will result in trade union taking some serious steps. So that's what I mean by, when the trade union goes, employer will be a little soft. When the trade union approaches employer with some demands, with some bedike, with some appeal, they will make with some demands, then employer will, yes, you have made a demand for increase of 1,000 rupees. But trade union, that it may not be to that form. But certainly we will get something out. I mean, it is better than, something is better than nothing. That is what the principle of negotiation, that is what the principle of bargaining. When the employer rejects the demand, you have put a proposal for 1,000 rupees increase. You have put a proposal for various conditions of employment. In such a case, at least by negotiation, employer will invite you for a negotiation. By this trade union and employer, it may be a bipartite or tripartite agreement. Remember, bipartite or tripartite agreement. What is my bipartite agreement? Between employer and trade union. What is tripartite agreement? Some independent person and employer and union. Somehow it's collective bargaining. What do you mean by that? The relationship can be promoted. It will promote a better industrial relation. It will promote compliance to the demands of the employees. It will promote a sense of understanding and commitment to the work. It will promote healthy working conditions. I said collective bargaining. When the employees through their trade union makes a demand, and employer will always be not that harsh to reject those demands. Of course, he may not be that easy to be fulfilling to their demands in the literal sense, to the 100% sense. Therefore, you will enter into some sort of agreement, and out of that negotiation, collective bargaining is a process wherein the employer and employees by negotiation enter into an agreement regarding enter into an agreement. An agreement is arrived at by consensus after negotiation. After negotiations connected with the terms of employment or conditions of employment. So better collective bargaining is arrived at. Collective bargaining promotes negotiations. Collective bargaining promotes mediation, arbitration or conciliation. These are the process wherein the trade union and employer, by their collective agreement, trying to promote, trying to implement whatever the demands, whatever the requests that have been made by the trade union. By this collective effort, by this collective agreement, the demands of the workers may not be fulfilled to the 100% extent as they wanted for, but it will be fulfilled in some or other form through this negotiation. So an agreement by way of a bargaining process, and this is called collective bargaining. What are the advantages and disadvantages of collective bargaining? As I said, advantages that it will arrive at a consensus. So industrial peace, better industrial relations, better conditions of employment, and prosperity of employment. Okay, yes, security of tenure, all that will happen. What are the disadvantages of a trade union? 1. Political interference. 2. Poverty, illiteracy. 3. Lack of appreciation on the part of the employee, members in the ability of the trade union itself, lack of appreciation in the ability of the trade union itself. So this is again, then the collective bargaining process, that it is a forced one. Whatever agreement, see, collective bargaining, an agreement is entered into, but agreement is entered into by whom? By the trade union. Whether it is wanted by the members of the trade union, question mark will always be there, right? You wanted it that time, got the agreement, but now inevitably after the agreement to resolve the dispute or the crisis or the rift, you have somehow resolved, but some may not be willing, some might not have been a party willingly. Okay, you are willing then, but now in course of time you may not feel like respecting the agreement. So, but you have no other go. You have no other go. This trade union and employer having entered into a collective agreement and arrived at a consensus to solve their dispute or the problem by way of collective bargaining. But actually speaking, it is either today or tomorrow. It will be turning out to be forced one. It is not voluntary, it is forced one. This is what the defect. And in a country like where we have got 16 to 17 million of the membership population to the total of 17 to 18,000 trade unions that we find in India. 17 to 18,000 17 to 18,000 trade unions are in India with a total membership population of about 16 to 18,000 millions. Sorry, 16 to 18 millions. It means 1 crore 18 lakh almost. Membership of total 17 to 18,000 of trade unions. Conflicting with so many thousands of trade unions around and so many millions, 16 to 18 millions of trade union population, membership population is there. It will be very much difficult that everything is arrived at by consensus. Everything will continue in consensus. One way or the other, they feel that it is involuntary, it is not voluntary, it is forced one. So something they don't appreciate at all. And some trade union, they will collude with the employers. And multiplicity of trade unions, as I told the number, 17 to 18,000 trade unions. One way or the other, they are affiliated to political parties. In the very establishment itself, the employees working in the establishment may be belonging to various trade unions. And these trade unions, one or other way, affiliated to political parties. So political affinity. And political parties are divided on the basis of their ideology. Political parties are willingly, sometimes political parties, your affinity to political parties will spoil your unity, cordiality. Therefore, industrial harmony is, in disarray, in complete disarray. As a result, you don't appreciate it all. Because we have trade union, I am a member of the trade union. But which member? Which particular trade union? Trade union backed up by BJP, trade union backed up by Congress, trade union backed by Communist Party, trade union backed up by some other. This kind of trade unions we have, the political affinities that they have developed, these trade unions. Definitely, political parties will one or other way, they will try to woo the support of trade unions in the elections. Therefore, obviously, that is the one factor which tends to divide and thus spoil the very functioning of the trade union. Collective bargaining has not been that successful in India for that reason again. Poverty, illiteracy, then as I said, the workers are in the unorganized sector and financial burden again. See, to conduct all trade union activities you require fund. From where to? The lack of finance is another contributing factor for the for the defective working of the trade union, where collective bargaining process is not that effective as such. So there may be a question like, what is collective bargaining? Collective bargaining means any collective agreement, any agreement entered into between employer and employees, employer and the trade union, in order to solve the industrial rift problems or differences and such an agreement is entered into by consensus between them by way of collective bargaining. So collective bargaining is a sort of an agreement to air out, to iron out, to sort out their differences. Okay, so that industrial peace or harmony will be, industrial relation will be safeguarded. That is what their objective. But whether it is been able to safeguard, whether it is able to be sustained, and refer to the merits and demerits of collective bargaining as such. In India, collective bargaining though has produced some results, but there are more reasons for its unsuccessful working that we can find rather than its success, right?